All right. Welcome, everyone. This is Curt.
Brad Pinsky.
All right. And we are here for another edition of Fire Law Roundup, this time for January 30th of 2023. And Brad, go ahead, take us away on this next last
Before
week.
I jump right in, I'd like to suggest you had sent out a survey to a lot of people. And I thought maybe you just want to take a second or two and talk about the survey, and hopefully people will fill it out for us.
Yeah, and the survey went out. It'll probably, if you didn't open the email, it's going to go out again on Wednesday, and it'll close on Saturday. So you've got a little bit of time. It's a simple. I mean, it shouldn't take you any more than 30 seconds to complete it. Very, very simple. But we're just asking if you're aware of Fire Law Roundup. Now, certainly, if you're watching this, then you're going to answer yes. Okay, but I think a lot of people. I've got roughly 75,000 people on the email list, and the results so far, I'm surprised how many people weren't aware of that. And then also equally weren't aware of the Fire Law Shorts, which is a shorter version. What I have my paralegal Malcolm break down the roughly 45 to 50 minute video that we do here, break it down into 10-minute chunks of different stories. So we want to make sure that folks are aware of that. And then also we want to kind of gauge, like, what does the audience want? What's the best way to deal with this? Is hitting you with 5 stories over 15 minutes to an hour too much? And maybe for some, maybe for many, that it is too much. Maybe you'd rather just get a 10-minute, although we have the 10-minute versions in the Fire Law Shorts. And one thing, they may be a little bit harder to locate. So that could be part of the issue. And I've got to work on maybe making my YouTube channel a little bit easier to navigate. And I profess, I think I'm pretty techno savvy. I'm not in Brad's league, but I'm pretty techno savvy. But I think Malcolm's got us both beat, and I think I'll work with Malcolm to get that channel looking maybe a little bit easier to navigate. But we want to figure out, and then also we want to make sure that this represents a tremendous investment in Brad and my time, and it's time taken away from our law practices and other pursuits. So we want to make sure that it's of value, and it'd be a lot easier for us to do one 10-minute presentation a week. And that may be the way we go. I kind of feel like there's too much information for just 10 minutes. So, but the bottom line is we want to deliver it, regardless of what I feel. We want folks to be able to learn from this and take something away. So if 50 minutes is too long, we have some solutions for that. If 10 minutes once a week is going to be a better way for us to package it, that's what we're going to do. So that's really what we're trying to accomplish with the survey. And Brad, I don't know if you want to add in.
No, I think that's it. We just want to know what you want to watch, and we'll deliver that. So,
yeah. I mean, we're both committed to this. We're committed to this. And I know, speaking from I enjoy doing it. I enjoy the prep, getting ready for it, and the things that lead up to us being able to do it. And then certainly the on-air interaction with my good friend Brad. So
that's really, I would do that. I was about to say I do it for free, but we're doing it for free.
We are doing it for free.
We are. So in that case, pay me twice. Okay, let's start in Michigan. This is interesting. We have a lieutenant who is alleging race discrimination. What I think is interesting is also that he's a paid on call lieutenant, not just straight employee, but paid on call employee. And he's claiming that he's being discriminated against because of his race. And he says basically that every time I want to apply for a chief's position, they move me to another station, which make it impossible for me to then qualify for the district chief position. And he said, look,
I don't understand that reasoning. I don't understand, because I'm not at one station, I can't get promoted within the overall department.
Yeah, well, he said, there's a hierarchy, and if you're not at the top of the hierarchy within your station, I guess you're not getting hired. But that makes no logical sense to me.
No, right.
But that's most of what it is. And he says, listen, he claims that the city of Farmington Hills has a unofficial policy. This would be like a Monell claim for those who watch. An unofficial policy, which is intended to exclude employees from professional development opportunities based on their race, so that you can't get qualified for the district chief positions. So
Yeah,
we'll see.
And if that's true, I mean, that shouldn't be happening. He's also alleging that they had criteria and he'd get the criteria and then they changed the criteria.
Right.
And if you're doing that along racial lines, no, hands down, that can't be happening. But the question becomes, is that really what's happening or not? And I guess that's what we'll see.
Does it affect white or non-African-American candidates equally, right, who would be in the same or similar position, or is it only disproportionately affecting him? Right, all things the city will come back to, and but look, they could also just say, we don't want you, right? We don't like you. They don't have to go through all of this to exclude someone from being able to be promoted. But we'll see what the city comes back and says ultimately. Okay, so in New York State, it's funny that this holding just came out, because if you've been watching Curt and I for the last couple of weeks, this is what we've been talking about. We started in Washington State talking about the public duty doctrine and how Washington State just limited that public duty doctrine to only those duties which were stated in statute versus the common law. And I said, well, that's very much similar. And you talked about similar and dissimilar to the special duty rule. So let me just revisit the special duty rule for everybody. And really, this type of case is what Curt and I are trying to deliver to everybody. And the method and how we deliver is we're trying to teach you law, right? And explain to you so you understand in your professional capacities the legal system and defenses and immunities you may or may not have, depending what state you're in. And here's just another good example. So the special duty rule, we could replay last week, frankly, but I'll do it quickly. So let me go back even one. In order to prove that somebody is liable for the injuries which you unintentionally caused to them, these are not intentional injuries, these are unintentional injuries, like I hit you in my car accidentally, or you died in a house fire because I didn't respond quickly enough unintentionally, right? So in order to prove that somebody hurt you unintentionally, called an unintentional tort or unintentional negligence, the plaintiff, the person suing you, has to prove that you owed them a duty, that you breached whatever duty you owed them because you were negligent or you failed to act like an ordinary, reasonable firefighter or whatever. And then third, they have to prove that their breach of their duty directly or proximately caused your injury, and fourth, that you have an injury. So what New York State and many other states do, but in New York State's certainly a very well-regarded rule here, the special duty rule, New York State says, listen, before we get to evaluate breach of duty, causation, any of that stuff, and even before we look at whether you even owed a general duty, when it comes to municipal actors performing a municipal service, and generally one that's discretionary, we're going to give a protection, a heightened protection to our municipal actors. And this is always why I tell at least New York firefighters, don't worry so much about losing a lawsuit, right? Don't try to get sued, but don't worry too much, because there's a lot of protections. And one protection is the special duty rule. So here, before you can ever proceed to did I breach any duty? Did I cause you any injury? Even if you messed up on scene, the courts say, but a municipal actor, a firefighter, a police officer, must have formed a special relationship with, and I'll give some examples and then we'll compare here, must have formed a special relationship with the injured party. So for example, in a very famous case in New York, a woman calls the police department and says, help, there's somebody in my house. I'm, stuck in a closet, and the person's going to kill me, and I'm hiding. And the dispatcher says, stay right there. We're coming. And then proceeds to send the person to the wrong address. Now, what then happens is the police go to the address, knock on the door and say, hey, we're here. Nobody's here. Okay. And they just cancel the call. They close the call. They don't confirm the correct address. The problem wasn't that they, in that case, that they went to the wrong house. It's that they never confirmed the right address. And then the person ends up getting stabbed and killed. And in this case, they said, listen, the dispatcher spoke to the person. The victim, ultimate victim, relied on the dispatcher and said, okay, I'll stay right here. And I relied because you told me you're going to do something that I knew if you didn't do, I would suffer harm. And those are very important elements when I discuss this case. So that's what it takes to form a special duty. One-on-one reliance between the person who tells you they're going to do something and the ultimate victim or the person who's injured, justifiable reliance by the victim, right? Who, hey, you told me you're going to send the police. I'm waiting. And I have to rely to my detriment. Okay, now let's compare that, contrast that with this case. Here, there is a fire already well involved. Fire department gets there, right? Chief gets there. All the apparatus aren't coming, and there's an allegation you didn't send enough, you didn't send them timely enough, they didn't get there, right? You're basic. You didn't get out in time. You didn't get to me in time. And had you done so, my house could have been saved. But the fire had already started. An assistant chief gets there and says to the homeowner, hey, relax, we're going to put the fire out, right? Like you would with anybody. We got it. We're coming. We're on the way. And then sues because, well, you didn't get it. You weren't on the way, whatever, and alleges you were negligent. Now, assume for the moment, because I want everyone to understand this rule, assume for the moment that the fire department really screwed up. It wouldn't matter. That's how strong of a protection this is, because the court said you didn't form that one-on-one relationship. But the little bit of different facts in here are interesting. So there's two things the court really looks at. One, the court says is, listen, even though the chief said to the homeowner, we got it, we're on the way, we're going to put the fire out, that conversation didn't cause the homeowner to rely on the chief, right? And all he was doing is reciting the general common law duty, because there's no law that says you will put out the fire, right? So at least in New York. And so all he was doing, says the court, was relaying, yeah, look, we're going to come and we're going to, fight the fire. So that duty, as we talked about, is owed to the public at large. And until I form a one-on-one relationship with you, I don't owe you any duty. And here he said, just telling them what you're going to do isn't enough. Now, that's very different than the police or the dispatcher saying, hey, we're coming to save you, stay where you are. Because the court notes the second part of this. The fire was already going. There was nothing the homeowner was going to do to change his conduct. Now, there is another case you, Curt, are familiar with where the fire department gets there and said, and the husband was trying to go back and rescue the wife.
Yeah, the Stoddard case.
Right, exactly. And the fire department says, we will go get the person so the husband doesn't go and get her. Now, frankly, they should have lost special duty on that because there was no one-on-one relationship with the person in there.
Oh, interesting. Right? Interesting. Yeah.
They should have lost that case. There was a special relationship with the husband who is not the victim. The husband didn't rely to his detriment.
Well, he lost something. He lost something. So
that's how they. In any event, here
the reason I'll come back to that because there's a line of cases that kind of tie into that too. But
and listen, I had one when I worked with the court system, and this is important to mention, where neighbors were calling on behalf of a baby and saying the baby's being abused, and so social services never went to check, so they sued the state because the baby ultimately was killed. And I remember the judge and I were very distraught, saying, how do we get past special duty? Because the state here screwed up. And ultimately, though, the problem is the baby didn't call, but somebody had to call on behalf of the baby.
There's a line of cases, Brad. It's totally ironic here. There's a line of cases where people have sued the fire department because the fire department didn't rescue an animal. Okay. And the special duty kicks in when you give assurance to the person, we're going to go get your parakeet, or we're going to get your dog, or we're going to go get whatever, your pet alligator, whatever it is. They make the representation that they're going to go in. And then once the person's kind of calmed down, they don't bother going in. And they say they had a special duty because they gave them the assurance and the person might have gone in on their own. Now, there's a little bit of irony there, is that somebody can have a special duty based on their dog dying and not their child. I mean, that's a little bit, that's a little bit of a stretch there.
Yeah. And here, though, it wasn't their child. It was the neighbor, not in local parentis, not in a parental position. But nonetheless, I mean, so these cases where the
in a wrongful death suit, you can file on behalf of the estate, so it would be. But the promise, you're right, the promise wasn't given to the child; it was given. Yeah. Wow. Yeah.
So very gut wrenching because I was part of it. But 25, 30 years ago. In any event, so special duty is so important. Just because, and what we want the viewers to understand is, just because somebody messed up, the negligence is down in the analysis. You got to start with, was there a duty? And when it's municipal action, was it a public duty? Was it special duty, right? What's the test in your state? If they were in Washington State, it's funny, we spend so much time talking about Washington State. If they were in Washington State, the court would allow this case to go on.
Right. And Illinois too, because Illinois got rid of the public duty doctrine. And I think, folks who've been following us are going to be a little bit confused here because, and you notice that Brad and I sort of struggle with this because Brad's from New York. In New York, they don't use the term public duty rule. They just call it the special duty doctrine, or special relationship or whatever. But to me, it's the flip side of the public duty doctrine, because you have the one side, if the duty that you owe is what you owe to the public, you can't sue on it unless there's some sort of a special duty or special relationship. So it's to me, it's the flip side of the public duty doctrine. But
it is. So anyway, that we beat the heck out of that. It's a great thing for everybody to know, but everybody should know it. If you're in public service and everyone's like, oh my God, we screwed up. Wait a minute. Did you owe a duty to the person? And so it's another protection offered to municipalities. Okay, let's go to Indiana. And we have a discrimination retaliation claim that was rejected. This is a lot of facts. I mean, I'll go through it, but maybe summarize it. But here's what I want to do, because otherwise we could spend another 45 minutes on this, the facts of this alone. So I'm going to summarize it, but I really invite people, go to your blog and read this, because this is such an insane set of facts. But here's really the short of it, right? We have an Indiana firefighter. He was demoted from captain to sergeant as a result of disobeying orders and spreading rumors about, you summarize it nicely, right, about a subordinate sexual preferences. And here's short on what happens. They find a video apparently of one of their firefighters. I don't know why this is online, but they find a video somehow online of one of their firefighters who is either gay or bisexual or whatever, but he's having relations with men, sexual relations with other men on video. Now, in pretty much every state, I'm not aware of a state that it's not, but I'll say pretty much, and certainly the federal government, right, you cannot discriminate against somebody based on their sexuality. But then he throws in saying, oh, since he's gay, he's also a pedophile, right? Highly offensive. And he starts saying, well, I have a real concern because look what he's doing. And everybody gets involved, right up to the chief of the department.
They get HR, they have this big meeting with HR and
the police get invited, right? But kudos to the administration. They investigated and found nothing here we could do anything about, no concern, and most importantly, no threat to children. And they almost say, how dare you make the accusation just because he's gay to say he's a pedophile? I mean, that's ridiculously offensive. So what then happens is that captain at the time wasn't happy with that, starts spreading rumors and continues to make the allegation, despite he knows it's true, that, oh, there's child protective concerns and he's a pedophile, right? Anyway, ultimately, everybody is disciplined. There's 3 basic tiers of discipline. One person is terminated. he is demoted and given a suspension, and then the person below him couldn't be demoted, so he gets a different penalty. But all three are treated, in a sense, equally to their level that they could be treated, but, on different standards, right? The captain, they say he's a role model. So he should have acted as a role model, so he was given a different type of sentence than the non-role model firefighter. And he sues and loses. And he sues basically saying he was, retaliated against, discriminated against, which I am so shocked that I'm offended at this person anyway, generally. And normally we don't make those comments, but if assuming everything the court said is true, is right, then this person, I can't believe he ever would sue. I mean, how does somebody think they really didn't deserve that discipline? And by the way, he admitted to it. He accepted it. He accepted the sentence. So once, generally, at least in New York, once you agree in writing, once you resign, once you consent, right, versus having discipline put upon you, once you consent and agree and plea and settle, you waived your rights to contest it, unless you were held at gunpoint. So I can't believe that wasn't part of it either. In any event, it gets thrown out, and it just shows you some people, even though they admit they've done wrong and they were told they did wrong, and they still just cannot accept you were wrong.
Yeah, it's almost like he doesn't realize how offensive his position on that issue is. And I can't imagine being in that HR meeting where they give him the opportunity to explain what is upsetting him about this particular firefighter. And the firefighter who is sort of the victim of the rumors is listed as John Doe. So they go into this HR meeting and say, oh, we can't have this John Doe with us anymore. We saw him on a video acting inappropriately. He's probably a pedophile. And so now HR meets and says, no, you guys can't be spreading rumors, and you especially, Captain, you can't be spreading these rumors. And he's not happy with that. He goes out and keeps spreading the rumors despite being told not to.
Right.
And persists at it, and then apparently, still isn't happy that he gets demoted. And I mean, he's lucky. Many places where if you're attacking someone in a protected class,
I would have fired him.
You would have been fired.
Of course, you should have been.
You raise concerns about someone who's in a protected class, then you ignore those and continue to persist in going after somebody who's in a protected class, and then you try to say, "Well, I'm in a protected class too," but I know it. So
being a toxic employee, so to speak, is not a protected class.
Yeah, just really, really unfortunate. But it sounds like the court's got it right in this one. But again, all we know is what's in the ruling, and what's in the ruling may not actually be everything that's out there as well. So we've got to keep that in mind as well.
Right. Okay, let's go. If you've been dead and not watching the news, obviously, and Chicago and Memphis and all that, but Chicago, we now have a fire department paramedic has been terminated. A second one's been suspended following the investigation into everything that's all over the news. I'm curious though what they did, and then I want to ask if you are aware of another case. But I'm curious. They're dispatched, right, for naked man lying in a parking lot in 22. He's allegedly or apparently hallucinating. He's on drugs. He's transported to the hospital, but they claim that he wasn't properly monitored. Now that, right. The problem I'm having is, and then he arrests and dies, right? But I don't know what the not properly monitored portion is. Is it I was on my phone not looking, or we didn't put a monitor on? And what's weird about this is the driver also gets in trouble. He's also suspended. And so I'm thinking, why is the driver suspended? Like, A, is he a paramedic? And B, what did he do? He's in the front seat. I'm not saying that he should have been. I'm just asking the question, what did he not do? But the paramedic, I assume you're supposed to put a monitor on the guy, and maybe he didn't. And, but this isn't a lawsuit. This is just, you're fired.
Yeah. I don't know what the restraints was like. I will tell you, whenever I see a case where someone arrested while in our custody, or they're basically our patient, I spent a lot of time as a ski patrolman and in Rhode Island and Maine. And one of the things that they emphasize on ski patrol is once you restrain someone, in particular, we do a lot of backboarding and collaring. But
Which is not restraining.
They can't move, and that's the point. Once you restrain someone, you are 100% responsible for their breathing, because they cannot, if they cough, if something blocks their airway, you've got them restrained. They are not going to be able to do what a normal person would do. So again, I don't know how this person was restrained in the back, but I know in fire service EMS classes, I don't hear that emphasized the way we do in ski patrol. We're on ski patrol. We got to bring somebody down 1,000 feet, down a slope, or however we got to do it. And that it's a little bit different. You don't have someone, and it's something that I've always been attentive to. And I notice that maybe sometimes the firefighters don't. I've seen medics have somebody on a backboard in the back of the ambulance, get out to go get information.
Right.
That is a absolute no-no. You got somebody restrained on a backboard, you're responsible for their airway. You can't leave them.
Right. I
don't know.
Yeah, I agree with all that. Although I've had this, I say we use the term package, not restrained, right? Look, Furno, Velcro headsets, right? You're not necessarily restrained. Now you duct tape somebody, you strap them, you hog tie them like we saw them the other week, and you place them on their face and strap them down, you're restrained. I would say just in a headset, Furno block, whatever. Okay, you can easily undo that unless you can't. So there is a fine line between restraint.
Well, I hear you, and how much of that was in here? But one of the things I noticed, and that's the thing that drew me to this article and looking at it, was we had the two firefighters two medics in Illinois charged with murder. Then we had two more from Illinois. These were from Chicago. They get disciplined over another patient death. And then now the next one is that whole thing with Memphis. And apparently there were medics on the scene, whether they weren't attentive enough, at least the allegations are they weren't attentive to enough. And I noticed really started in 2016, we started to see lawsuits that we previously rarely, if ever, saw. And these are lawsuits against firefighters and EMTs who were at the scene of an unruly citizen who is at the wrong end of the police baton and passes away. And now not only are the police officers being sued, but we're starting to see the medics and firefighters being sued. And we've seen a dramatic increase. And really, we're going back to Michael Brown and what happened in Missouri there. But we're seeing an increase, and firefighters have got to realize that this is an area that it's emotional, it's hot, and you have got to be on your game when you're going with the police to these types of incidents.
Yeah, and you and I are going to talk coming next month on that. We're going to have an hour-and-a-half session on that very topic of who's in charge, and the lawsuits that people are seeing. One of the causes of action, right, as we know, is denial of life or liberty. So when you are truly restraining somebody, you've denied their liberty, you've seized them. So I mean, yeah, we are open up as EMTs, first responders. Boy, you put your hands on a patient in a non-medical capacity and you're in a lot of trouble. And this includes, we're seeing like paramedics deliver Haldol at the police's request to calm someone down, right? I mean, I don't know what it is that I get we want to bond with the police, but we're not police. So
yeah, it's a big problem. We looked at ketamine as another big problem area, but I think to the firefighters and medics out there, when you're going on a run to assist the police and they have just apprehended someone, whether they're naked and sweaty or otherwise impaired, or they're the victim of just having undergone some sort of altercation with the police. This is one of those events that, to me, should make the hair on the back of your neck stand up if you're concerned about liability. This is one of those things. It's like a Mayday where you've got to be on your game, because what you do, how you treat that patient, and the outcome of that could dictate whether or not you're going to end up with a civil suit, or in that Illinois case, I forget what town it was in, but it wasn't Chicago. But in that Illinois case, the medics were charged with murder, first-degree murder.
Yeah.
You know, so there's criminal and civil consequences here.
And, you know, we haven't talked about this, but in my city of Syracuse, where at least my law firm is, there is just a case about 3 weeks ago where and it's a great issue. It's going to be in our course. We're going to use it, but where 2 medics responded with a off-duty police officer. The police officer got a call from his sister who was involved in a DWI arrest. So the Syracuse City police officer leaves his post, travels 10 miles outside the city, goes to interact with a cop, instructs his sister, don't answer questions, don't say this, tells them to fake you have a medical condition, right? All bad cop stuff, but enter the paramedics, who then give her IV fluids, not needed, but only so as to dilute the blood alcohol. And they are now subject to arrest and I think have been terminated, but they're under arrest.
Wow.
They've been charged.
Obstruction of justice? What are they? Really?
I assume so. I assume so. All to try to dilute blood alcohol. So again, I think your point, my point is, paramedics for the last 5 so many years or whatever are really getting a little brazen and overstepping their boundaries. And the simple one-word advice I think you and I have for them is don't.
Mm-hmm. Yeah, and I think you've got to understand is maybe they are getting a little bit more brazen, but I think the public is looking for people to villainize, and we are in their gun sights. You know, firefighters and medics, we're wearing a uniform, and people in uniform, to many people out there they're not part of the good guys. And we think we're good guys. I know we're good guys, but they're looking for people to blame when things happen. And you've just got to be on top of your game when you go on these types of incidents.
Right. And don't give in to the cops asking you to do things that you shouldn't be doing. I'm sorry, that's not my training. I'm sorry, that's not my job. I'm sorry, right? I'm sorry, but okay, last one. Also in New York, now we're at the FDNY. I'm a little surprised at, well, I'll tell you what I'm surprised at in a minute. Let me give you the facts. So we have an FDNY EMT. She was being harassed, touched, inappropriately talked to by an EMS chief. FDNY does what it's supposed to do, investigates, all right? Even tells that chief, you may not retaliate as a result of this complaint. You may not retaliate against her. The FDNY takes appropriate action against him, I would say, but nonetheless, he is still permitted to retaliate. Permitted, I don't mean authorized to. He was specifically told you may not retaliate, as any good employer would, but then he is retaliating against her. And so she now sues. The interesting part, and she says basically that the FDNY failed to take prompt and appropriate remedial action to protect or correct further discrimination, right? Or harassment, which is retaliation. And she basically says, I'm under increased scrutiny. You know, let's stop here for a second. The problem is, once you have been found by your employer to have sexually harassed somebody, anytime you try to discipline them for anything legitimate, it's over, right? It's going to come back as harassment. There's no way, especially in a big organization, that he should ever have direct or even indirect contact with her again, right? I mean, that's the problem. You can't, everything you do is suspect from that point forward. Even if it's legit, she's going to file a claim no matter what. And I'm not saying she's wrong. I'm just saying, as a general matter, your supervisor harasses somebody, he can't supervise her anymore. Now, if he didn't really harass her, it's different. But here's the interesting thing. In New York, at least, who has some of the most strongest sexual harassment, sexual discrimination laws in the country, and I'm not understating that. We probably have the strongest laws protecting the victims. But once a supervisor harasses you, especially a chief officer, this is EMS chief officer, once he is found to harass you, FDNY, the employer loses you. Loses the case, sorry. In any job, when your supervisor, whether it be a lieutenant up to a chief, is the one doing the harassing, the employer is imputed with the knowledge of the harassment because it's a supervisor doing it. They don't have to report it. They don't have to complain about it. You lose the moment a supervisory personnel harasses the employee. So I'm surprised, and you've got to give the woman credit if I'm correct. She could have filed a suit back then. It doesn't appear that she did so, right? So buying her a lot of credibility. She could have won against the FDNY just based on the chief's harassment. Now it took alleged retaliation to get her to file a suit. Now that could be for a lot of reasons. Maybe she missed a deadline. Maybe she just didn't want to sue her employer. She was happy with the respect she got. But at this point, she's now suing, saying he's retaliating, and that's enough. But I think this case is more useful for those points. Your supervisor harasses you. How can he supervise you again? And two, you don't need the further step of a retaliation to be able to sue. Once he's harassed you, it's over. But this is worse if true. Yeah,
I got a really nasty phone call on this case after I published. It really kind of nasty phone call from a woman, I believe from New York. I don't know which side of the case she was on, but she said, you really ought to investigate the things that you're writing about. And I'm like, she wasn't very nice about it. Okay. Yeah. And I'm like, well, if I'm going to talk to somebody in the case, the problem, if they have an attorney, I'm an attorney. I can't talk to someone who's involved in a case without going through their attorney. That's unethical, number one. But they're not going to talk to me. If I call somebody, they're not going to, and many times I have reached out to attorneys and stuff. Do you have a comment? Do you have a comment? Nobody wants to talk. Nobody's going to give you the time of day. So I don't have a squad of detectives that I can put on a jet and fly them out to New York or New York City and go around prying before I blog. But what I do, I try to stick with what is in the complaint. And the fact is, a lawsuit was filed. That's a fact. Right. The allegations in the lawsuit are what's in the blog. And that's all I can do. I mean, it's not CNN, it's not Fox News. I don't have this big, entity out there that I can send reporters out to research this stuff. So, point being, there may be other sides, and not just to this story, but there may be other sides to many of the stories. So, in fact, there's no doubt in my mind there is another side to this story. Okay, but it's beyond my ability to go get it. And also, Brad and I have degrees in how to screw with people. That's what a law degree is. If you're going to call me at 11 o'clock at night and think you're going to yell at me, I got a couple of volleys for you that you're going to receive. And so if you want to talk nice, I can talk nice. I've got a degree in doing that as well. But if you want to talk nasty, you're going to get it back.
And look, you and I, not to defend ourselves, but you and I are so careful as much as we can be about saying the court held this, so that's what our facts are upon, or the allegations were this, or assuming only for the minute that this is true, right? I mean, we don't know, but the lessons here are in the allegations or the findings or the conclusions, right? And that's what we're reporting on. And look, if you're one of the hundreds or thousands at this point with you of people who are involved in some of these cases, I'm sorry you're involved, unless you're the winner, I guess, but we're just reporting on what is alleged or what's in a piece of paper. That's all we can do.
I was doing pretty good with it until she said, well, if you were really a firefighter, and then I kind of lost it at that.
Yeah. Insult me as a lawyer all you want.
Yeah, right. Exactly. Don't say if you were really a firefighter.
Right.
What the F do you mean by that?
Yeah. Wow.
My wife is looking.
Right.
So
Anyway, well, that's where we are for this week and another good week of cases.
all right.